After 2 days of CPDP, we finally arrived at the topic of the day, the DMA.
Wow. Good.
And the fact that that was actually not a joke already tells you a lot about me. So my name is Jürgen Bering. I work at an organization called Gesellschaft für Freiheitsrechte, GFF. It stands for Society for Civil Rights. We are based in Berlin, and we do focus on litigation, so we're a civil society organization. And we also do a little bit of work on the DMA front. Before I'll introduce the rest of the panel, allow me quickly, for those few stragglers that actually might not know what we're talking about, what the DMA is, to give a very, very brief intro. At the same time, I feel, because there's so many other very interesting panels going on, that this is probably the crowd that really has a lot of knowledge about this already. So the DMA is a relatively new instrument. It does regulate the digital market. That's why the name. And while it's not competition law in a classical sense, it has been created to alleviate some of the failures that we saw from competition law. Specifically, that in competition law, there is the idea that something was violating competition law, and then basically 10 years later, we know whether that's the case or not, which is very, very slow for digital markets. So the idea of the DMA is, how can we do this in an ex ante way? How can we prohibit some behavior before all these court proceedings? And how this is working, we'll hear now a little bit from the panel, with a large focus on enforcement, both from a private perspective and from a public perspective. And to discuss that, I have 4 brilliant minds here with me on the panel. Let's start with Lucas Lesota, who is the legal program manager at the Free Software Foundation Europe. He has worked extensively on issues such as device neutrality, the open internet regulation, interoperability under the DMA, and the legal implications of platform lock-in. In addition to all his advocacy work, he is also a researcher and teaches on technical regulation, communications law, and digital rights at the Martin Luther University in Halle-Wittenberg, which is a very good university. I studied there. And then about the FSFE, there's many things to know about the FSFE, but there's a very recent big success, because they've been granted leave to intervene in the case Apple versus Commission, so a big DMA case that is going on. And I'm hoping to hear a little bit about that in a moment. Then we have Maria Luisa Stasi from Article 19. She leads the digital markets work there, and her work specifically focuses on the intersection of competition law, platform regulation, and freedom of expression. She has a particular expertise on the DMA, media regulation, and just generally the broader impact of digital market structures on fundamental rights. Before her work at Article 19, she worked in legal practice as well in academia as in policy. And another very important thing to know about Isa, and why she also sits on this panel, one of the many reasons why she sits on this panel, is she is also a class representative against a competition law case against Microsoft and the UK's Competition Appeals Tribunal at the moment.
Super cool.
Bringing us to Vanessa here. Vanessa is currently a partner in the Brussels office of Mulvaney and Myers. She advises on EU competition law and the digital markets. Before that, she worked at BERC and was already there involved quite a lot with the Digital Markets Act and consumer protection in general. Earlier in her career, she served in the cabinet of Competition Commissioner Neelie Kroes and advised the US Federal Trade Commission. And then I have put down, she did hold a lot of positions in very different fields, all related to this work. So she's seen many different sides of this. And finally, this brings me to Filomena Chirico, who is the Deputy Director for Platforms at DG Connect. She also leads the unit in charge of the implementation of the Digital Markets Act. Before that, she was a case handler at DG Competition and worked as an expert for the Cabinet of Commissioner Thierry Breton, where she was specifically responsible for the negotiation of Digital Markets Act and Digital Services Act. Before all her time at the Commission, she was also in academia at the Tilburg University. And Without further ado, allow me to hear some opening statements, starting with you, Lucas.
Okay. Yeah, it was a bit of a surprise. So thank you very much. First of all, the organizers to open the panel to us here. Also, Jürgen, for this initiative. It's a great pleasure to be such a qualified table, giving the butterflies in my belly. But I would like to kick off a little bit engaging with the audience with a small question. Who in the audience use iOS, iPhone? Okay, the vast majority. Who uses Android? Okay, there's someone. But now the nerdy question. Who uses a third operating system? Android-based operating system? No. Not a Windows phone? No. Okay, no. Right. So perhaps this quick social experiment demonstrates that the vast majority of this room also reflects the reality of the digital markets, that we have just two mobile operating systems, and Google and Apple, they dominate 99% of the mobile operating systems, and this is a challenge for digital markets. And mainly because when we think that when digital markets are not working properly, and then comes regulation, and these companies starts to drag their feet on the regulation, then perhaps litigation becomes a tool for the competitors, for civil society, to make this regulation work. And since the DMA has this system that, well, the European Commission is the main enforcer of the law, we think as the FSFE, as a civil society, that helping the regulator to implement this law in a way that is software developer friendly, well, saves us a lot of work. Otherwise, we will have to do this alone on the court ourselves. But then that's why we do think that, well, helping with public enforcement or also private enforcement is very important to make digital markets, well, at least more contestable and fair.
Thank you very much, Lucas. And you're not the only person from civil society on the panel. We also have Isa. And so my question is, so we already see how, like, to generally make this work, but what is your experience so far in regards to, like, to enforcement, Isa?
Good morning. My understanding, not my understanding, but I think that in the general narrative, when we talk about the DMA, we talk about the Commission and the gatekeeper, and this is the public enforcement layer. And I think in the past 2 years, a lot has been done, a lot has been discussed, we've seen a lot. But I still, when I go here and there and I say, private enforcement, people are quite skeptical. In general, I think all the stakeholders, for a number of very, very good reasons. So while I completely agree with Lucas that because this is a matter this is something that matters for everyone, private enforcement cannot be underlooked, I will also consider as sort of an overall duty for civil society to sort of try to work on the complementarities of these two things. As a society, we don't necessarily need to pick one. We need both. We absolutely need both for a number of reasons. First of all, because the DMA has a great potential, is different from competition, because I would argue, and I've argued and I will keep arguing this, it has the possibility, it's not about stopping a negative behavior, it's about building or re-engineering the digital markets and the digital environment that we want for our society. So it goes well beyond. But we have the European Commission on one side that is getting equipped as much as possible and is doing what they can do, but it's an asymmetric battle. It has always been, and again, I don't think this is going to change in the near future. So there is a massive power imbalance, and that's where the complementarity between private and public enforcement kicks in. And I think that to a certain extent, we need to make sure that this complementarity goes smoothly, because otherwise the risk is that the European Commission, rather than being the primary enforcer and someone that opens the door and leads on this, will be a bottleneck. So I think that the private and the public enforcement can be seen as two legs of the same body. And there would be many advantages if we start talking more about the private enforcement and start doing more of private enforcement. And we have legal expertise at the table, so I'm not going to be the one telling you how many problems we have from a legal perspective to get this going. But if we manage to have those two, we can have many advantages, and I'll focus on three just initially, and then we discuss wider application. The European Commission has to prioritize cases. The DMA contains a lot of obligations, and we have a number of gatekeepers, and it's not an easy task. So in a way or in another, they need to say, okay, this is the priority. This is what has more impact on society. This is what we've seen more. We go for this. What about the rest of the cases? We can either wait and see and if and when it's going to become a priority, or we can go to court. We meaning everybody. And then again, the legal problems of everybody is going to be dealt by someone else here. So this is one advantage. The second one is the DMA is new. It's a new piece of legislation. We've had it for 2 years, but we're already seeing a lot of problems, well, not problems, novelties in the interpretation, the benchmarks, what compliance means, how we interpret this provision as that provision, and so on and so forth. So we need to create this. We need to sort of create consensus. We need courts to test this. So if we go to a number of courts, we can have a little bit of experimentation, mutual learning, and we can do all this testing and defining, and it will lead to so there are two possibilities to look at this. One is to say this is going to make the enforcement very fragmented, but the other way to look at it is this is going to create legal certainty in a shorter time frame. In order to do this, we have a couple of tools. One is super powerful, which is the preliminary ruling. So every national judge can go to Luxembourg and say, can you help me interpret this so that I don't mess it up? And I'm sure that we go all in the same direction. Another one is the European Commission going directly and talking with the courts. So the judges can say, well, there is a proceeding that came to my desk. You are investigating on this. Can we have a chat? So this is another powerful instrument. And then the third one is, let's train the judges. We've done this for competition. We've done this for GDPR. There is no reason why we shouldn't do this for the judges. Actually, the judges at the court in Luxembourg and the referent there, they've been trained. They're looking for cases. They find them, I've been told, they find them very engaging. So, we need to bring them more cases. So this could be also all mitigation risk for fragmentation and empowering the legal certainty in a shorter time. Last point that I want to make, last third marvelous advantage, the deterrent effect. Scenario A, we have gatekeepers who are extremely powerful, and they need to comply with a piece of legislation. And what they do, they offer a service, they test whether the way they offer the service is compliance or not. They engage in a regulatory dialogue, they come up with another solution, there are other 6 months, then we need to start talk with the market stakeholders, then there is an investigation, then at some point there is a specification decision, a year and a half goes. You go to court, the pressure, maybe the court case in itself takes even longer, but the pressure is there immediately. So if we create an environment where the gatekeeper know that whatever move they do on the market, there is an army of individuals that can easily go to court and say, this is against my rights, we need to stop this. This is a completely different scenario. So that's what I would start from.
Right. Thank you very much. And I'm pretty sure we'll talk a lot more about these deterrent effects, complementarity on this panel. But before we get there, let's talk a little bit about what has already happened in the last 2 years in regards to public enforcement, and what are some of the barriers? What do we need to know about all of this? Philomena.
Thanks. Good morning, everyone. Every time I listen to Isa, I get a lot of new ideas that I should have put in my introductory remarks. Let's see what comes out of my mouth now. No secrets and no confidential information, that I can assure you. But let me say, from the perspective of a public enforcer, the point Isa made a number of points, amongst which how the DMA is a new instrument and is different from competition law. I think it's different from competition law from various perspectives, and one of them is the fact that the DMA, as we know, is not there to correct the problem that we have ascertained after 1, 2, 3, or 10 years, but is there to preempt problems, saying this situation should not occur to begin with. But that means that if everything goes well and everything in the law is respected right away, then the regulator has no role. You don't even see the regulator. That's I call it a bit the curse of the regulator. It looks like the regulator has been doing nothing basically, and the market just works wonderfully. Well, luckily or unfortunately, things don't go that way. So the regulator always has something to do. The other difference is that most of what we do happens behind the scenes. Now, not as a case, not as taking a company to court, not as fining a company. There is a lot that is going on, and I would say like the tip of the iceberg is actually the actions, but most of what we do is below the surface. And if you see now, yesterday we adopted the third annual report of the DMA. This time we really try to make it short and sweet. It's like 15 pages, and it only says, also because we have the review that just came out, so there are a lot more things in that report. But there, what we try to say is like, not how many decisions, how many preliminary findings, how many whatever formal act we have taken, how many openings. Yeah, there is that part too, but it's what has actually happened. Because that's what we do every day. That is not a case, is not a proceeding. And there you have information about the new data portability APIs, or the new interoperability of the new messaging services that are providing interoperability with the designated, in this case with WhatsApp. You have out there now, more recently, you also heard from other sources, the results in terms of opening up the browser sector to more alternatives. And despite all the difficulties, we have alternative app stores on iPhones, which most of us have in our handbags or pockets, with all the difficulties. Now, is the work done? Absolutely not, otherwise we wouldn't even be here discussing. So the curse has not yet materialized, and there is more work to do, also looking forward to it, looking forward to what is there. And that's another difference that I see in the way the DMA, or we think about the DMA. We just opened new chapters in the DMA that concerns new services, not the traditional ones where we knew that there were issues to correct, the operating systems or browsers and so on. But we are looking into cloud, we are looking into how to enable AI markets to stay open. And we hear a lot, but you shouldn't touch because this is still evolving. Well, we are not touching the AI market per se. We are just enabling more competition and more openness, so that no matter whom, because we know, and the DMA has embedded this, the dynamics that we see in the digital markets, that when you have an ecosystem, the company that runs the ecosystem try to leverage where they have a big presence to also promote their service elsewhere. Well, the DMA has some backstops to this thing, saying, for example, that if you have an operating system that is designated, so is in a specific position, well, you cannot favor your own products. You have to give the same conditions to the others. And that's what we are looking at, for example, in the recent specification on Android, opening Android for the AI features, AI-related features. So this is a bit what we were, say, what some of the things that are going on in the machine room that we are thinking about, and we are also doing when you see. And maybe one last comment is that I still keep hearing like, yeah, okay, it's been we adopted the DMA, and you told us that now markets would be free and open and fair, and yeah, that didn't happen. So DMA is a failure, or we didn't manage to solve the situation in Iran, so the DMA is a failure. So there is a bit of an expectation, which is good because it pushes us to do our job better. But at the same time, change takes time. there is also a change. We have had the digital markets working in a certain way for 20 years. And if we want certain things now to change, it's not only about imposing the law, it's about creating also the culture and the education in the users, us, on, for example, being again able to make a choice even if it takes 2 more clicks. So that's something that comes out there quite often. Like now I have yet another click. Yeah, in a way, somebody said freedom doesn't come for free. In a way, you have to make an effort even, or choice doesn't come for free in this case. Well, I'll leave it there for now, and then happy to move to more the interplay with the private enforcement.
Vanessa, we just heard change takes time. Choice does not come for free. What is there for private enforcement to speed this up and to make sure that we have choice?
Right. Well, thank you very much for the invitation.
You've got 5 minutes to change the world.
Oh, yeah, absolutely. So I'm sure I'm going to succeed in that one. Well, actually, I'm going to go backwards rather than forwards first. So in our tango of public and private, I've been tasked with the private enforcement side of the equation. And so whilst recognizing the absolutely vital public enforcement part that Filomena set out, I'd like to delve briefly into the legislative history of the DMA insofar as this is relevant for private enforcement. Bear with me, there is a reason for this. And because I want to see what we can learn from this legislative history. So in the Commission's first draft of the DMA, private litigation through collective redress actions to enforce the DMA was not included, nor was the input of third parties enabling business users, companies, and civil society to play a role in public enforcement, which to me seemed like a bit of a flaw. So thanks to the efforts of some of the people on this panel, the final text of the DMA actually includes both. Now, I would say not 100% perfect for third parties' involvement in the public enforcement, but I would like to recognise that Filomena and her colleagues do a lot to involve third parties with the provisions that we do have in the DMA. And before turning to private enforcement, I would like to say that I think the involvement of third parties, civil society and other, in public enforcement is extremely important. First, in helping the Commission to enforce the DMA through the provision of evidence and information. Second, because public enforcement is less costly for civil society than private litigation and should be faster than going to court. And third, because I think involvement in the Commission proceedings allows third parties to become more familiar with the issues that are at stake, and that is useful also for private enforcement. So now I am actually going to turn specifically to private enforcement. And if we look at private enforcement of the DMA, individual claimants can bring cases, so business users or end users in DMA terminology. They can bring actions for injunctions to enforce the DMA and for damages actions where the DMA is not being complied with, provided they have standing under the law. I think we can say that this is absolutely clear from the fact of Article 39 in the DMA, which regulates the relationship between the European Commission, on the one hand, as the public enforcer, and national courts hearing private party proceedings on the enforcement of the DMA. And we've actually now seen a number of cases being brought by both business users and end users and civil society. For example, the one mail and media Google Gmail case in the Regional Court of Mainz, judgment of August last year, and then the VZVB Meta AI case in the Cologne Court in Germany, again from May of last year. So there are actions that are being brought. But then I wanted to focus in particularly on collective redress actions by citizens to enforce the DMA, because that's probably the most realistic way for citizens to be able to enforce their rights under the DMA. And that is now enabled for the DMA through the addition in the legislative process of 2 articles on representative actions. That's Article 42 and Article 52 of the DMA. And these articles enable representative actions where DMA infringements by designated gatekeepers harm or may harm the collective interests of consumers as end users under the DMA. And this is achieved by bringing the DMA, like the DSA, into the annex of the Representative Actions Directive, the RAD, as I'll call it from now. Because that then allows qualified entities, so bodies who represent civil interests, consumer interests, to bring injunctions to enforce the DMA and damages claims for compensation if there is a failure to comply. And those actions can be domestic, they can be cross-border, and designated entities can even join forces to bring cross-border actions in a single representative action. Potentially also, but this will depend on national law, a civil society can bring follow-on damages actions after public enforcement. So that's another route to be taken. Now, the point of going through all this legislative history is that it was clearly the intention of the DMA legislators that business users under the DMA and end users should have the right to enforce the DMA through private litigation. I mean, and Isa's touched on some of this already, but not only can this lead to greater compliance by gatekeepers and compensation for failure to comply, but it can also have a deterrent effect that you mentioned against non-compliant, and it could also be a counterweight to potential regulatory capture as posited under capture theory. Therefore, I think it's important that business users and civil society users can use these rights to litigate, but also important to be able to use them effectively. And we'll come back to that, what that means in the panel. I mean, there are still barriers, later in the panel, there are still barriers to the effectiveness of private enforcement outside of the DMA itself. But the key point that I want to make here is the law as it stands can now be used. And given that in the last 2 years that we've been talking about, there have been points in this time where I've been quite concerned about public enforcement of the DMA in the current geopolitical context. And I think that overlay makes private enforcement of the DMA all the more essential, not only for business users to thrive and for consumer choice under the DMA, but also, in fact, to preserve the rule of law. And I'll leave it there.
All right, thank you very much. I would like to now open it a little bit more for the panel, but picking up on what you said last, with the geopolitical level of it. So we've all experienced how the pressure, especially from the US, has been increasing. There are reports that even some public enforcement decisions have been postponed because of it. In any case, what does this specifically mean for enforcement? How do you deal with enforcement in a world where it's not just you going up in an asymmetrical way against a big platform any longer, but also where this suddenly gets a geopolitical level? What does it mean for both public enforcement, but also for private enforcement? And Philomena, would you like to start us up on that?
Yeah, no, it's a hot topic, but it's been a hot topic for quite some time. Let me try to demystify also a bit the situation, not to minimize what's, the geopolitical situation is what it is, but in a way, there is always political steering and priority setting that takes place in enforcement actions. So this is not something that didn't exist before, of choosing the direction in which you go, the priorities, what is more important, what is the timing. This has always been done everywhere, all authorities, independent or non-independent. That's what happens all the time. And that also means taking into account the context clearly. That's part of what the politicians have to do. On the other hand, as an enforcer, the Commission is bound by the rule of law. That means two things. The Commission can only do what is in the law. And on the other hand, the Commission must do what the law says they must do. So, for example, all this, in the middle, of course, there is the discretion that the regulator has. That's a bit in an abstract, it's a bit abstract, but to say, if you look at what we are doing, and I try to sketch a bit some of the things that we have done in the past year, say, as enforcement being slowed down, I think we have done a lot. we have really gone after many things, opening up AI, looking into cloud, for example, looking into interoperability. We had specifications, we had still open cases, and I know that I'm perfectly aware that people are eagerly awaiting the closure of the still open cases. So let me tell you this one bit. Decisions will be taken, because decisions must be taken. That's the point where the Commission must take a decision. It's written in the law, we will take a decision. Okay? But once we have taken a decision, that's the bridge with private enforcement, perhaps, that does not solve the problem. It's just certified that there was a problem. So I think there was also a question specifically on this recently to our spokespeople, to say, like, we are looking at what can be done to actually change the situation for the future, not only to ascertain that there was a problem in the past. So that means perhaps taking a bit more time, but let me say, and besides all the procedural elements that need to be finalized to make the decision solid, that stays as always, because, as I said, the rule of law. But I think also we said already, and the Commission said publicly, we gave a bit of time. Time is not infinite, and time is running out. So that I think I would leave in terms of what is still open, but bear with me about the fact that a lot is happening, a lot. We have opened new specifications, we are looking into search data, we are looking into interoperability with new agent, AI agents, and a lot more. So I know that there is a link of closing cases and private enforcement, so I'm leaving it to the private enforcement colleagues to make that link now.
No, definitely.
This is super interesting, and to a certain extent, I wish that that would be the reading of each and every enforcer, and I'll tell you why. Apart from the fact that I completely endorse that, having a rule of law system is a duty as much as it is a right. But anyway, I agree with the fact that a decision per se doesn't change the scenario, and then there will be other actions being taken. Although if we pile up a number of decisions, then obviously the deterrent effect is slightly different, or it goes in the direction of creating the compliance culture that I think we discuss a lot of time. But to facilitate the bridge in between the public and the private, maybe one thing to be done is, and this is why I said I wish the mindset was the same for each and every regulator. Is a decision written thinking about whether this could be potentially an enabler for private actions, follow-on actions, or is a decision written and shaped thinking we need to do a snapshot of the present and this is what we need to do and we stick to that, etc. I know those are nuances, but are potentially a big enabler. If I, as a civil society organization, I read the materials, the European Commission is producing a lot of materials about the DMA compliance, a lot. A, we have access to a part of it and not the bulk. And B, sometimes it's written in a way that is very much a sort of a public enforcement, compliance with the specific obligation mindset, rather than being written in a way that could enable damages actions, for example. And for the sake of it, we know that if a number of damages actions are out there, then the cost of compliance become higher, and maybe this has an influence on the change in the business model. So this is one thing. How the decisions are written, if they're written having this in mind, how much of the materials, the precious materials that you produce with all your investigation power that are inaccessible for private parties, how much of this is made publicly available, it could be used, and if we have any leverage there. The other point is, I believe that one of the enablers of private investigations or private actions would be to sort of have more participation in the DMA enforcement. So you rightly said there is a lot going on behind doors. You have no idea how much overloaded we are. We can roughly imagine. But maybe there is a lot of other capacity or evidence or technical expertise out there that is fragmented, and nobody is there in their little bubble thinking, maybe I could support this if I only had a structure that links all this capacity and brings them to the right avenue so that it can be used for the benefit of everybody. So those two things, how much is already done and produced and how to make it more accessible, and how to, on the other side, make everything that is out there, not in the public enforcement, but out there, is fragmented, how we can concentrate this and make it usable.
Anyone else wants to add on that? Because otherwise that will just bring us to our next point directly, which is the fact that, so we're talking about public and private enforcement, complementarity. At the same time, we're sometimes forgetting, I feel, that the DMA is not the first time we're talking about public and private enforcement, and there's a lot to be learned and about also like how to take all of the aspects or the information coming from public enforcement into then private enforcement. One specific area that many on the panel have a lot of experience on is competition law, but there's also other areas of law. And so the question is, what can we learn from that? What are the things that we need to take from that? What are also the mistakes that maybe we need to avoid from these areas of law? And I would start with you, Isa, on that one.
So I think there is a difficulty there so the DMA attributes business rights, rights to business users and rights to end users. So I want to see this as a good thing. I want to see the half full, not the half empty. Meaning that with the GDPR, most of the time is about an individual going to court and say, well, my personal rights and so on and so forth. Here we have also another potential ally or another potential actor, which are the business users. And why this is important? Because it's difficult to access the evidence. So I might say, well, the pay on consent, it might be an easy case for an individual to be argued, but the majority of it is about technical issues and about the relationship between the business users, the gatekeepers, the business users, and how this impacts the end users' rights. So the GDPR can help us on one side. The DSA cases, I think they're a good learning point, because also there we have this complementary private, public, how it's going to shape, how it's going to work. So it's very good to go in parallel. I wouldn't be particularly inclined, obviously we can learn from the competition scenario as well, and I think we need to learn from the weaknesses of the competition path. Because it took a lot of time before any private enforcement of the competition rules took place. It took a lot of time for a long list of reasons, including creating this private enforcement culture around Europe, which I don't think it was there. What we can learn is also that there is still a lot of fragmentation at national level. So for a civil society organization, it's absolutely not the same thing to bring a case in the Netherlands or to bring a case in Germany or to bring a case in Spain or to bring a case in Italy. There's so many different problems and hurdles. And so forum shopping by civil society is one of the main things you need to think of. And there we can look at what went well or not in other cases. So again, learning. I think the other point, and then I'll leave it there, without getting into the legalities and the technicalities, etc. Coordination. So we have had in competition a number of cases, but that I know, it was rarely a coordinated action in between different civil societies or different actors in the different member states. And so it was very random judgments that we got every now and then. What I think we need to sort of figure out is how to make this systemic, how to work together, how to sort of reinforce each other's actions. And this can be a game changer. Otherwise, is extremely risky and is financially very, very costly. And I don't think civil society can play a role in there.
Lucas, do you share that?
Yes, I would like to contextualize a little bit what Isa has very good pointed out. As soon as an industry becomes important enough, in society, it becomes subject to regulation. The digital is a little bit, ideologically has been marked that it should not be susceptible to regulation. But we regulated industry in the past. So think about the automobile industry. In the 80s, it was not compelling to use safety belts, But today, can you ride without wearing a safety belt? Think about the pharma industry, But the digital, nowadays, the tools are telling our children, are telling our young people to kill themselves. Chat bots are telling them to kill themselves. The digital should be regulated, And the DMA comes in this mind change shift that the digital should and can be regulated. And of course, the subjective of this regulation, they wanted to resist this type of regulation. And we see them now with the geopolitical claiming that DMA is discriminatory against some companies. No, DMA works for the public interest of us that are using these devices on an everyday basis. So, of course, this panel is about enforcing privately and publicly the DMA, but we need to leave behind this idea that the digital is different, that the digital cannot be regulated. Innovation is the most important thing. We all want our systems to be more secure and more private. And there is no other way around if these companies are not doing this. We need to do this via regulation.
Thanks. I just wanted to maybe pick up on some of the points that Isa made and maybe expand on some of those, because I think she, looking at it from the competition side of things, which is where I have spent a lot of my life. Firstly, just coming back onto the validity of private enforcement, I think competition law has shown us that direct enforcement of EU law in national courts is perfectly possible. We go back, and you mentioned the timeline, it's absolutely true. We go back to the early 2000s with cases like Courage and Korean. And there the courts actually recognized that not having that ability would actually put the effective enforcement of the law at risk. And then indeed having private enforcement on top of public enforcement really strengthens the working of the competition law rules, and I think the same could apply to the DMA. However, the other flip side, and Isa also hinted at this already, is that those cases at the same time recognised, and I think this is an important point, that in the absence of EU procedural rules, it's for the domestic legal system to decide how you can bring cases. And that is a potentially a problem. But those cases also said that domestic law should regulate it, but subject to two important principles: equivalence between national and EU law, and effectiveness, and we'll probably come back to effectiveness later. So we do actually see today in competition law actions being picked up by private claims which are not being picked up by public enforcement, whether by the Commission or under competition law or national competition authorities, and Isa is living proof of this, in fact. So, and we also see follow-on damages, which are now starting to be successful in a number of jurisdictions, Germany and France, the Netherlands. I won't go into the details of that. So I do think it is a good avenue. So that's one lesson we can learn. It can work and it can benefit globally. The second lesson, and I've already hinted at it, is that in order, and so has Isa, in order for private enforcement to work, it really has to be effective. And Isa rightly said that it took a long time for competition law enforcement to take off, and I think that's true. And I think it wasn't really until the adoption of the damages directive, which introduced a number of procedural rules for private litigants. So presumption of an infringement of the law if that was found by a national competition by a competition authority, access to evidence, rules on quantification of harm, limitation periods, all those kind of things. So that really made competition law private enforcement much more effective. Now, I mentioned the RAD earlier, which kind of sets the ground for collective redress actions under the DMA, but it doesn't really help much on procedural issues which are left to national law, which leave us with a patchwork that Isa mentioned, which is not really ideal for anyone in a single market. A lot of member states use tort to allow for claims in this respect. Others have used other legal bases, and so there's quite a bit of a mess there, which leads to the forum shopping issues that Isa mentioned, which I think, we can come back to this, and I think needs tidying up. The third thing that I think we need to learn from competition law was that at the time of the adoption of the DMA, of the damages directive, there was quite a strong outcry that, oh my goodness, this is going to lead to US ambulance chasing style litigation. Well, I think 10 years on from the adoption of that directive, we haven't really seen that. So I think one has to always take that argument with a pinch of salt. And on the other hand, enforcement litigation in the US has not been all bad. We have actually seen some really interesting litigation dealing with important societal issues which haven't been tackled by public enforcement. So I think we can certainly learn from this. So I'll stop there on.
No, maybe more listening than anything else, because we are on the receiving end of the private enforcement experiences that are being brought to our attention. I'd say, how would I think about this? And I think also Isa said something in this respect about the complementarity of the actions that can be taken. There can be complementarity in deterrence, as you said, although that requires coordination, at least in terms of coordination of views, not that you coordinate in the past, but we have instruments, as you also recalled, Vanessa. There is complementarity in redress, of course, because then the redress only happens in private enforcement. But then where it gets more complex for me is the complementarity in, you could call it remedies, I would call it changing the behavior, changing the market dynamics, changing what is out there. Because there is the point where the fragmentation might be more risky and the risks may be more acute. So in this sense, I think I actually have in mind a positive example where the Mainz court in Germany decided about the tying between Android and Gmail. And we were discussing exactly the same thing with Google in our regulatory dialogue. So at the end, there was a nice alignment from our perspective that we were going in the private litigation and in the discussions in the same direction. But there are quite a few private litigation that I'm aware of in Germany in particular, a lot of lower courts that are looking at it, the Netherlands as well. In the Netherlands, I remember there are private individuals that are going to court about one or the other right. So that's also probably the small claims court, which is also not particularly expensive. But what if the court starts interpreting the DMA and says something that is not exactly what we are discussing with the company, because maybe we don't have a case, because as I said before, and I keep stressing, not everything is a case, but we are still discussing with the company. So how does Article 5.2, the data combination, apply when we're talking about training of AI? So that was a case put to, I don't remember if it was Cologne or another court in Germany. So these are the points which, despite on top of the complementarities, can create also the risks. And as you correctly said, all of you, there are mechanisms in the DMA. You have, of course, you always have the preliminary rulings, but you have the amicus curiae. You have the one thing that I like very much of Article 39. The court can ask us to give them the information that we have. So, to your point of access to information, so that's actually something that the court may do. On the other hand, I mean, amicus curiae. How many courts do we have in Europe? I mean, if the Commission had to just participate in every single private enforcement case at all levels of the court, I mean, there is some balance to make between intervening and say, okay, maybe it's a higher court. That's when things are becoming crystallized. Maybe that's the moment to intervene and say, no, this is the way we look at it. So this just to put there also some things to think about from my perspective that we should be mindful when we think of private enforcement.
And especially staying at this interplay. So you already brought up Article 39, which gives the ability for courts to ask for information, but also like from a private enforcement perspective, it also has this dimension of potentially staying proceedings, which is something that from a private enforcement perspective is relatively risky. Vanessa, what is your experience so far with that, or what do you think about it generally?
Well, let me start by saying I think consistency is an important issue. I mean, clearly the purpose of the DMA was to have harmonized rules across the EU. So with that as a backdrop, and I guess in an ideal world, you would have a public enforcer who could ensure that, would have the resources required to do that. Unfortunately, we don't live in an ideal world. So that does bring us right into this area of Article 39. So Philomena has already mentioned a number of the sub-articles of that, which are basically designed to allow for consistency and amicus and all the rest. But I'm going to focus on the last one, this Article 39.5, which basically says national courts may not take decisions which run counter to decisions adopted by the Commission under the DMA. Logical. They must also avoid giving decisions that would conflict with the decision contemplated by the Commission in proceedings it has initiated under the DMA. To that effect, the court may assess whether it is necessary to stay proceedings. So, I think that what all of that means is not 100% clear. So let me give a few examples. So first question, does Article 39.5 apply beyond non-compliance decisions to other types of decisions, so specification decisions, for example, or designation decisions? Now, one view that I've seen is that such a broad interpretation would not be the right one by analogy to competition law, but is that what the wording of Article 39.5 says? Secondly, when, and I think this is a key question, is when does the court actually have to stay proceedings? So Article 39 refers to courts suspending their proceedings where a decision is contemplated by the Commission and in proceedings it has initiated under the DMA. So that's what Article 39 says. Article 20 of the DMA says where the Commission intends to open proceedings with a view to possible adoption of various types of decision, it shall adopt a decision opening a proceeding. And then Article 5 of the implementing regulation says, the Commission may decide to open proceedings with a view to adopting a decision at any point in time, but no later than the date on which it issues the preliminary findings, that it must make the opening of proceedings public. So my first question is initiation and a decision to open proceedings the same thing? Now, you mentioned the Mainz court, which I think is interesting because there, the gatekeeper in that case asked for a stay of proceedings, but the court, as you mentioned, said that, the argument was because there's a regulatory dialogue going on and a national decision running counter to this could violate Article 39.5, the court should stay the proceedings. But the court actually rejected that, saying that irrespective of whether the Commission has already initiated proceedings in this case, there is no statement as to what the decision the Commission intends to what decision the Commission intends to adopt, and the Commission was obviously aware of this and didn't do an amicus in that particular case. So no stay was granted. I think we're going to be testing whether a stay would be granted in the eDreams case in France, because again there, the gatekeeper has requested the court to suspend proceedings on the ground that the Commission is looking into the same issue and there would be a risk of conflicting decisions. Now, looking at that from a more philosophical perspective as well as a legal one, if national courts were to suspend a proceeding just because the Commission has started to look at an issue, to my mind, that would not be appropriate. Because, as we know, there is a significant amount of non-compliance by gatekeepers at the moment, 2 years on from the entry into force of the DMA. And the Commission, as I said at the beginning, does not have unlimited resources. It's not the Commission's fault. But in those circumstances, is it justified to stand in the way of others enforcing their rights under the DMA in the name of consistency? And I stress that I do think that consistency is an absolutely key point here. But given the Commission's limited resources, it could undermine the DMA if the enforcement of the DMA if the Commission were to open proceedings if it was not seriously progressing an investigation and thereby blocking the civil society or whoever to bring private enforcement. And so that would be one issue. And there's a second issue, I think, in the sense that when the Commission is looking at issue, we don't always know what the scope of that issue is. And if a private litigant wants to bring a proceeding but avoid an overlap, it's hard to avoid an overlap if you don't know if there would be an overlap or not. So I'm wondering if there is some kind of mechanism that, respecting confidentiality, and I realize it's not easy, but it might be useful if one could sort that out. Because it just seems to me it can't, in the name of consistency, limiting private enforcement to follow-on damages actions can't have been the intention of the legislator. So particularly as we know that litigation will go on for years and the Commission's decisions will be appealed through the courts. So if it's 10 years before you can bring a private damages action, I don't think that was what was intended. So that's raising a lot of questions without a lot of answers, but maybe Filomena can give us some answers on how one could navigate that effectively to ensure the complementarity.
I'm not sure I have the answer, but we wish that at some point we also have guidance from the court on some of those things, as I think you were also wishing a little bit earlier. So what I think that relates a bit to another point that you were making before about the participation of third parties. Because we are, as a team, irrespective of the fact of having specific procedural rights similar to competition law or not, third parties are extremely welcome to participate to proceeding, to give input, to discuss with us, to help us understand. So we cannot do it without. That's the body of knowledge that we need to build together with the market players. So in this exchange, there are a lot of things that we say, that we can say because they're non-confidential about the way we are looking at things, and that already gives some indications to third parties about this. We are also, compared to other areas of law, and I know we all have a past in competition law. I think the DMA way of also communicating to the public has been different because it's a regulation. So we can, if I'm a competition enforcer and I'm doing an investigation in what might or might not be a competition infringement of one of the two articles that discipline the market in this sense, here I have a number of provisions that say this is forbidden. So I can say I'm actually looking whether what is happening, which is public, is violating or is respecting, I should say, is respecting the provision that imposes not to self-preference, not to self-prefer. I don't know what's the right way of making the verb. So in this sense, there is a lot more out there about our regulatory dialogue, which we are talking about quite openly in the bilaterals, in roundtables, in workshops, than what was done in past regulatory experiences. So for me, that is in the current framework, what we have started doing. There is a lot probably that we can still learn by doing with in the interactions and in the cases, and with the guidance at some point also from the court when we get to there. So I think at the same time, not only change doesn't happen immediately, but also the learning of the new instrument takes some learning by doing in a way. So I don't really have an answer, definitive answer, but I hope that some input for your further reflections and actions.
Right. Before opening up to the public, I wanted to ask Lucas a final question, which is about interoperability, which seems one of the biggest promises that the DMA has. What is your evaluation of the status of that, and especially what role does enforcement, public and private, play in that specific part?
Yes, so I'm very happy to see that the European Commission takes interoperability as a priority for the enforcement. I would like to elaborate a little bit the role of interoperability. First, it's a difficult word to pronunciate, interoperability, but it has a very important meaning. Interoperability is like a can opener of infrastructures. You know, it keeps the companies honest, and I explain why. Because interoperability allows consumers and allow business users to move away from the term ecosystem if they are not happy with that, because then they can just move and make their system to talk with another system. And interoperability is also marked by a contradiction. When the companies, they are small, they like interoperability because they want to get more value of their product by connecting their product to, well, the incumbent product. So it brings value, remember? So think about any charger out there that wants to make their USB compatible, because then they can connect to your Android, to your Apple device, right? But as soon as the company becomes big enough to be subjected to interoperability regulations, they step back. And they move to another concept called compatibility, you know. And compatibility is when the company makes their systems compatible inside a silo, inside, an ecosystem, right? But interoperability is way more sexier, in my opinion, because then it makes these systems compatible across ecosystems, right? And Google and Apple, and other gatekeepers, they benefited a lot from interoperability in the beginning of their histories. Think about Apple. Apple did not have an app store when Apple launched the iPhone in 2007. But then they saw an opportunity to bring developers in the ecosystem, and that was the best decision they make, because now they make billions of euros in profit with their app store. But it was a decision to open up their systems to interoperability, to make iPhone to third-party developers. And by the way, installing a software in your device, it is interoperability. So you make a software that was developed by someone else, and then it runs on your device. So people call it, in the DMA context, vertical interoperability, right? But the problem is as I said, and although Google until recently was also very open to interoperability, now we are seeing that they are closing more the ecosystem. They are moving more into this compatibility concept. Well, but the Article 6.7 and Article 7 of the DMA, it doesn't speak about compatibility. It speaks about interoperability, the sexier part, you know. So and therefore, we are seeing gatekeepers to react violently against interoperability. And in 2023, Apple started litigation against the European Commission, questioning the constitutionality of the DMA altogether because of the interoperability obligation of Article 6.7. And they claims that Article 6.7 impacts disproportionately their intellectual property rights and the other rights because of interoperability. But one thing that happens with the European Commission that I found extremely interesting was when the Commission decided to regulate interoperability via the specification decisions, which we welcome that very much. I think it was a huge improvement in how we see interoperability in digital markets, and this is in the global level. So the European Commission is in the forefront of the interoperability regulation, telling the entire world how we should look into interoperability in digital markets. But what happened, it was really interesting, because Apple was saying, you are violating Article 6.7 is disproportionately affecting our rights. And then the Commission said in the hardware specification, okay, so can you please list the patents that you think that is disproportionately affecting your rights? They didn't come with a list. So, and then what Commission said, and correct me if I'm wrong, Commission themselves performed a patent search, and they come up with one patent, and they listed it on the specification decision. So there's a lot of hype around interoperability. Oh, interoperability is bad for intellectual property. Interoperability is bad for security. I will repeat myself again. we take a very serious and responsible approach towards security and privacy. And we do believe that interoperability is better for security and privacy and not worse for it. I don't want to be dependent only one gatekeeper. As I said, interoperability keep them honest. If they started and we heard yesterday on the panel where the Norwegian consumer organization was, and they talk about the institutification of the digital markets. So if a company starts to institutify their own systems, interoperability allows me to jump outside of this ecosystem and go to another one, right? So therefore, on this backdrop, we saw an opportunity to support the European Commission on their public enforcement of the interoperability when Apple started litigation, and not only one. Now we have 3 litigations on Apple against the European Commission because of interoperability, software interoperability, hardware interoperability, the concept of interoperability in general. And in our position, we do think that interoperability has a social function. You know, as soon as services start to be more complex, we need interoperability to increase welfare, consumer choice in digital markets. And if these companies, they do not want to cooperate, the state must come and must regulate them, right? And therefore, we were super happy, and I would like to again commend on what Filomena just said, that the Commission welcomes. So in our 2 interventions, we are intervening on the case that Apple brought in 2023. Commission supported our intervention there. Now we submitted also a request to intervene in the case which Apple is appealing the specification decision. Commission also supported our intervention over there. And but again, there's a lot to be done. And what we are doing is also we are monitoring what Commission also open up transparency, how this gatekeeper should treat the information that they implemented interoperability solutions. And one key aspect which Commission did was to impose on Apple in the specification decision that they should provide data on the interoperability solutions that they do, right? So there are some KPIs they should open up and say, look, this is how we are doing. So a lot of transparency on the decision-making of the interoperability grants. And we have been analyzing this data. So recently we look into this data. We look into 56 interoperability requests that Apple has received from third-party developers, and there is still no interoperability solution. So before the specification decision, Apple granted some interoperability, but now with the specification, Apple has not granted any interoperability solutions. So that's why this shows the importance of civil society to be involved in this program, in these processes, to, well, inform the public, right? And this is not a topic for nerds. I would like to finalize this. This is not a topic for nerds. Interoperability it's key for consumer choice. It's key for fairness of digital markets. It keeps companies honest, you know. So I'm looking very much forward to this intervention of civil society in these very important cases.
Thank you very much. We do have 5 minutes for questions. I would like to gather 2 to 3 and then open it up for the panel. Yep, the 2 people that raised their hands.
Thank you, Katarzyna Szymilewicz, Panoptykon Foundation. Thank you, Lucas, for your point about interoperability. Maybe it's more a comment than a question, because I understand that you are discussing enforcement of what we have and not of what we could have with the revision of the DMA. But my comment is that as organizations that represent people on the ground, we would be much more likely to try private enforcement if there was, if the interoperability obligations were applicable to social networking services, and there was just more law on the table for us to try and enforce. I mean that right now DMA is an excellent tool for new market entrants and for businesses, but it includes less obligations that are relevant for real consumers. And because DSA is also not ideal in that respect, it did not went as far as to require interoperability. And we already hear from the Commission, different part of the Commission, that DFA will not cover that either. Then we are back to DMA revision. So probably Philomena cannot comment on this, but yeah, it's just a comment that we would love to see more interoperable obligations that have a meaning for consumers and could open gates for private enforcement in the revision. Thank you.
Yeah, thank you for this excellent panel. In its recent DMA review, the Commission decided against amending the DMA and just changing enforcement practices. But nonetheless, I'm wondering if there are any regrets, either on the side of the Commission, the on the side of the Commission, the co-legislators, or just policymakers writ large, regarding some things that were omitted. And obviously, Kasia mentioned horizontal interoperability for social networking services. But I'm also, since this is also a panel about enforcement, I'm also wondering if there are any regrets regarding not including the supervisory fee like we have in the DSA, given the Commission's limited resources. And finally, I think another question or another point that has been sort of overlooked are the designation criteria for core platform services, because Article 3.1b states that what's really important is for the main criterion is essentially that the core platform service is an important gateway for business users to reach end users. And of course, you need to have 10,000 business users and 45 million end users. However, this seems to have raised certain issues in designation. So, for instance, I know the Commission has opened qualitative designation proceedings for cloud services, but none have been designated just under the quantitative criteria. And similar for virtual assistants. And then also Facebook Marketplace was then de-designated because Meta stepped up its enforcement and bans on business users. And especially with horizontal interoperability, it sort of doesn't make sense if that platform only has end users, because there are no business users that could reach those end users. Right. And that's not what IMSS was designated.
So yeah, we have very limited time left. Do you have responses specifically about all of your regrets? I hope you don't have too many, to be honest.
I have a whole list which I'm keeping for the next. Let me just say, the DMA is a young instrument, and we all said it. We haven't even finished using all the tools that are in the DMA. Yeah. We just opened not only the market investigation for designation of cloud, but also the investigation to perhaps adapt the DMA to cloud, which is a very innovative way to just tweak the obligations to the changes of market reality. So we haven't even finished that, and we're already changing. I think at some point we also need to see what the tool, the instrument can actually do. And on the disappointment of the social network discussion, I think when we negotiated the DMA, there was a discussion on interoperability of social networks, and we said, I was in those negotiations, and where we kept asking on the Commission side, what exactly is it that we want to achieve? Cross-posting, cross-likes, what is it? And there was never a clear either understanding or demand for certain things. So we said, okay, the Parliament said, look at it in the next years. We looked at it in the next 3 years. And I don't think things have changed much from, or my impression. But one thing that is really, that I found really interesting, and that you can see in the report and in the report of the study that we also commissioned, is that people haven't only spoken about horizontal interoperability, but about vertical interoperability of social networks, which was never a discussion during the negotiation. And that is perhaps a conversation that is starting only now, so may need a bit of still some discussion, but that I found a very interesting insight, that now people are talking also of the 6-7 perspective, not only of the Article 7. So I think this is a conversation that will continue in the future.
I have a PhD that talks about vertical interoperability, and the publication was out in 2022. No, I mean, I see, but now more broadly. It is a new tool, and I think one of the mistakes we can do is to run before we learn how to walk. I totally agree. But maybe one of the ways is also to sort of use better the expertise that is already there, because we're all learning, but if we learn together, we learn faster, I think. And hence, coming back to the topic of this panel, you know, private enforcement can be something, because otherwise it is very uneven. And the only thing I suppose the Commission doesn't want to do in all this is to become a bottleneck rather than be a good leader.
All right. And with that, we end this panel where we learned that competition law is not just for nerds, where we learned that interoperability is sexy and many other things. Hope to see you here next year. Take care.